There is a particular miscalculation that people make when they have access to powerful resources. The miscalculation is not in having the resources. It is in believing that the moment to deploy them is the moment when things are not going the way you expected, when the room is not responding the way rooms usually respond, when the person across from you is not behaving the way people usually behave when you are who you are. The resources become a reflex, a reach, the human equivalent of a safety net that has been there so long you have stopped being careful because you know it will catch you. The problem is that not every room has the same ceiling and not every net is rigged the same way, and occasionally you reach for something in a place where it does not exist, and the reaching itself becomes the most consequential thing you do all morning. Simone Arquette was 34 years old. She was a film producer, not the kind whose name appeared in small print at the end of a long list of credits, but the kind whose name came first, whose name was sometimes the reason a project got made, whose relationships in the industry were the kind that opened doors that stayed closed for most people, regardless of how hard they knocked. She had produced 3 films in the past 5 years that had collectively grossed over $1 billion. She was, in her world, a person of genuine consequence. Decisions she made in a morning meeting could alter the trajectory of projects that employed hundreds of people. She was used to the weight of that. She wore it comfortably. She was in Providence for reasons that had nothing to do with film. Her sister lived there. She visited several times a year. On this particular visit, she had rented a car at the airport and driven into the city and had, over the course of 4 days, accumulated a set of circumstances that brought her into Judge Caprio's courtroom on a Thursday morning. The circumstances were these. She had received 2 parking citations on the same street on consecutive days, which suggested that the first citation had not produced any adjustment in behavior, which was its own kind of information about how she was processing her situation. She had also been cited for making an illegal turn at a marked intersection captured by a traffic camera. And there was a matter of expired temporary registration on the rental vehicle, which was the rental company's technical responsibility, but which had created a complication at the time of the turn citation that had added a layer to the stop and extended it in a way that had clearly not pleased her based on the officer's notes. She came to court alone, no assistant, no representative, no advance team, just herself, which was either a sign of confidence or a sign that she had assessed the situation and determined it did not require reinforcement. She was dressed well in the understated way of people who had moved past the phase of dressing to impress and into the phase of dressing to be comfortable in the knowledge that they already had. She carried a large phone in a smaller bag, and she moved with the directional efficiency of someone who did not waste motion. She checked in, found a seat, and within approximately 90 seconds had her phone out and was working. Not scrolling, working. Responding to things, initiating things, the focused, rapid engagement of someone for whom the concept of downtime was a theoretical one that applied to other people. A court officer asked her to put it away. She held up one finger, the universal gesture of one moment, and continued for approximately 15 more seconds before putting the phone face down on her knee, which was not entirely the same as putting it away, but was close enough that the officer let it go. When her name was called, she moved to the front with the pace of someone who had other things to get to. She greeted Judge Caprio with the professionally warm efficiency of someone who had conducted 1,000 meetings and knew how to establish a productive register quickly. She said good morning. She said she hoped they could move through this without too much trouble. She said she knew he was busy, and she certainly was. Judge Caprio said good morning. He did not respond to the framing of efficiency. He looked at the file. He took the time he always took. He asked her about the parking citations. He asked her why she had returned to the same street on the second day after having been cited on the first. She said the street was close to her sister's apartment and that the parking situation in that area was genuinely difficult. She said she had thought she had found a spot that was technically legal and had apparently been wrong on both occasions. Judge Caprio said the citations indicated she had been in a no parking zone both times. He said the signage on that street was not ambiguous. He said it was marked clearly. She said she might not have read the signs carefully enough. She said she was distracted. She said she had a great deal on her mind during the visit. He asked about the illegal turn. She said the camera must have caught her at an angle that made it look worse than it was. She said she believed she had been within the legal parameters of the turn. Judge Caprio said the camera data showed otherwise. He said the data was time-stamped and geometric and did not have angles in the way she was describing. He said it showed her vehicle in the intersection in a position that was not consistent with a legal turn. She looked at him for a moment. She recalibrated. She said she would defer to the data. He moved to the registration issue. He explained that while the technical responsibility rested with the rental company, the operator of the vehicle bore a practical obligation to ensure the vehicle they were driving was legally registered, particularly for extended use. She said she understood that in principle, but that she felt it was unreasonable to expect a rental customer to verify the registration status of a fleet vehicle before driving it. Judge Caprio said he took her point. He said there was genuine complexity in how liability was distributed in rental situations. He said he would address that element with appropriate consideration. It was all moving along, contentious in small ways, but manageable. The kind of proceeding that arrived at a conclusion through the accumulation of small exchanges, each one establishing a little more of the picture. And then her phone, which was face down on the surface in front of her rather than her bag, lit up. She glanced at it. She picked it up. Judge Caprio said her name. Just her name. Quietly. She held up the finger again, the one-moment finger. She said it was important. She said she just needed 30 seconds. Judge Caprio said she could take the call outside and return when she was finished. She said she would rather take it here, if that was all right. She said it would be very brief. She said the person calling was actually someone who might be useful to this conversation. The room absorbed that sentence. Judge Caprio asked her what she meant. She said that the person calling was her attorney. She said he was very familiar with traffic law in Rhode Island. She said she had mentioned to him that she had this appearance today, and he had said he was happy to speak with anyone who needed clarification on any of the relevant statutes. She said she thought it might actually save everyone time. Judge Caprio looked at her. He said that was an interesting approach. He said he had a few questions before they went any further. He asked whether her attorney was licensed to practice in Rhode Island. She said he was licensed in several states. She said she believed Rhode Island was among them. Judge Caprio said he would like to know for certain. He said that was not a minor detail. She looked at her phone. She said she could ask him. Judge Caprio said he had a better idea. He said she should answer the call and put it on speaker. Something moved across her face, a brief calculation. She had not expected that. The offer to bring the attorney in had been made as a kind of leverage, a way to introduce a more powerful voice into the room, someone who spoke the language of law with the fluency and authority that she felt was currently working against her. She had expected the introduction of that name, that resource, to shift the dynamic. She had not expected to be invited to put it in the middle of the room where everyone could hear it. She answered the call. She put it on speaker. She set the phone on the surface in front of her. A voice came through, male, confident, with the particular resonance of a man who was accustomed to his voice carrying weight. He said hello. He said he understood he was speaking with the court. Judge Caprio said that was correct. He introduced himself. He said his full name and his title and the name of the court. He said it clearly so that there was no ambiguity about who was on the other end of the call. There was a brief pause from the voice, a small recalibration. When it continued, it was still confident, but with a slightly different quality, the quality of someone who has entered a room and found it is more formal than they expected. The attorney said he was calling on behalf of his client, Simone Arquette, and that he wanted to offer any assistance the court might find useful in understanding the nuances of the citations she was facing. Judge Caprio thanked him. He said that was generous. He said he had a few preliminary questions. He asked the attorney to confirm his name for the record. The attorney gave his name. Judge Caprio asked him to confirm his bond number and the states in which he was licensed to practice. Another pause, longer this time. The attorney gave his bond number. He listed his states of licensure. Rhode Island was not among them. Judge Caprio said he said he wanted to note for the record that the gentleman on the phone was not licensed to practice law in Rhode Island. He said that he was therefore not in a position to represent his client in this proceeding or to offer legal guidance within this jurisdiction that the court was obligated to treat as authoritative. He said he appreciated the call, but that he wanted to be clear about what it was and what it was not. He said he also wanted to say something to the attorney directly. He said that when a client appeared before a court of law, the appropriate time to arrange legal representation was before the proceeding through proper channels with formal entry of appearance. He said that a phone call during an active proceeding, however well-intentioned, was not a mechanism that the court recognized. He said it was not how things worked in this room, regardless of how they might work in other rooms. He said he understood that from the attorney's perspective, he was trying to help his client. He said he took that at face value. But he said that what had actually happened was that his client had, in the middle of her own court appearance, reached for a resource in a way that was designed to change the dynamic of the proceeding rather than to engage honestly with its substance. He said that impulse was understandable. He also said it was not something he was going to accommodate. He said to the attorney, and he said it with a directness that carried through the speaker without any distortion, that the most useful thing he could do for his client right now was to let her stand in that courtroom and address her situation herself. He said that she was an intelligent adult who was fully capable of doing that. He said that the attempt to introduce external authority into the room was not helping her. It was, if anything, complicating her position by suggesting that she could not or would not engage with the court on its own terms. He said he wished the attorney a good morning. He said he was going to continue with the proceeding now. The call ended. The phone sat on the surface between them for a moment. Then Simone Arquette picked it up and put it in her bag, this time all the way in her bag. She did not do it with resentment. She did it with the measured movement of someone who was making a decision about how to proceed and had decided on a particular direction. She looked at Judge Caprio. She said she wanted to apologize. She said she had thought it would help. She said she could see now that it had not. Judge Caprio said he appreciated that. He said the apology was accepted. He said he wanted to ask her something, and he wanted her to answer it without thinking about strategy, without thinking about how the answer would land or what it would produce. He asked her to just answer it honestly. He asked her whether she was used to being the most powerful person in the room. She looked at him. Something shifted in her expression, not offended, but genuinely surprised by the question. She said yes. She said she supposed she was. He said he thought so. He said that was not a criticism. He said that she had earned that position through real work and real talent, and he had no doubt that the rooms she usually occupied were rooms where her authority was legitimate and appropriate. But he said that this room was not one of those rooms. He said that in this room, the most important thing was not who had the most resources or the most connections or the most powerful person available by phone. The most important thing was the law and the facts and the honest engagement of the person who stood before him. He said that in that specific sense, every person who stood in that spot was equal. The resources disappeared. The connections disappeared. The phone went in the bag. And what was left was just a person and what they had done and what the law said about it. He said that for people who spent their lives in rooms where their power was the defining variable, this room could feel disorienting. He said he understood that. He said it was not meant to diminish her, it was meant to include her. To say that the same process that applied to everyone else applied to her too, and that was not an insult. It was actually a form of respect. She was quiet for a moment. She said she had never thought about it that way. She said she had come in thinking about how to manage the situation. She said she realized she should have come in thinking about how to address it. Judge Caprio said that was a meaningful distinction. He said she had just articulated something that many people never arrived at. He went through the citations. He applied the fines methodically. He addressed the rental registration matter with the nuance he had promised, noting the shared responsibility and adjusting accordingly. He was precise and fair, and the process was clean. Before she left, she asked him something. She said she hoped it was all right to ask. She said she was curious about something she had observed during the morning, watching other cases before hers was called. She said she had noticed that he seemed to genuinely enjoy it, the work, the people. She said most of the judges she had encountered in professional contexts, in contract disputes and intellectual property matters, seemed to be managing volume, getting through it. She said he seemed to be actually present with each person. Judge Caprio looked at her. He said that each person who stood in that spot had a life that extended in all directions from that moment. He said he had learned a long time ago that if he wasn't paying full attention, he was missing most of what was actually happening. He said the violation was usually just the door. What was behind the door was always more interesting. She nodded, she thanked him. She left the way people leave when they came in one way and are going out another, not dramatically transformed, but shifted, carrying something they didn't walk in with. Outside, she sat in her rental car for a few minutes before starting it. She sent a message to her assistant. She called someone back. Then she sat quietly for a moment longer, which for her was unusual enough that she noticed it, the sitting still, the not immediately moving to the next thing. She thought about what he had said, about the room, about the resources disappearing, about what was left when they did. She started the car. She checked the mirrors carefully, which she had not always done. She pulled out slowly. She drove back to her sister's apartment through streets that were the same streets they had always been, full of people moving through their days with their own weights and their own destinations. None of them managing her, none of them resources, all of them just there, just present, just as real as she was. She had known that, of course. She had always known it. But there was knowing something, and there was being in a room where a man looked at you and said it plainly and meant every word and would have said it to anyone. That second kind of knowing felt different. She thought it was probably the more useful kind